All right, now we have Mr. Severin de Wit here with us. He's an expert in intellectual property rights. Mr. de Wit, when you think about the law of the future and intellectual property rights, what are your thoughts?
Well, it's an interesting question, especially as I've now been in the conference for almost 38 hours, and unfortunately I haven't heard anything like the role of intellectual property, or more generally access to knowledge, because intellectual property has much to do with proprietary rights to knowledge. And how can this influence the future of law? Right? And so we had a discussion with some of the participants, unfortunately not at the conference, about what is the role of, for example, standard setting organizations. Let me say this, in a system whereby companies are setting the rules who can enter a market because you have to comply with certain technical standards, and they basically force either to force or ask companies to contribute, which participants in the market can actually be a player. That's what standard setting bodies do. They use intellectual property as a main factor to do that, which is all an area where private actors mainly dominate. It's not like a state tells you how to behave in a market for mobile technology. It's the private actors that do that. And so what you will see is that the more the state retreats from intellectual property type or access to knowledge type issues, the more private actors will step in. And you may wonder, and that's what the future will bring, how far do states or other actors in the market allow these private actors to basically set the tone in terms of access to market, access to information. I was talking about mobile technology, but I think more maybe interesting for younger people to understand is the whole debate that's going on to access to medicine for countries that can't afford or that don't have a system whereby they can afford to pay for the royalties for pharmaceutical inventions, and in how much are private players like pharma companies obliged to give people access to disease controllers that they normally wouldn't have, or set the pricing for that matter. All these questions are very relevant. We have rules in Europe that tell us which goods can be stopped at the border from either China or the United States because of intellectual property. I mean, we have now countries that complain, India, Brazil, that the Rotterdam Harbour, the access to the European Union, is being used by owners of intellectual property to basically stop the distribution of some goods based on patent law. Do we agree on that? We have issues of innovation. We learned at school that the reason why there is innovation is because the state says, if I have found something that's of value and that is new and inventive, you get a patent. And why do you do that? You get that right, a monopoly right, for 20 years in exchange for you telling what it is that you have found. And by doing so, you will help others to build on stand on the shoulders of the giants. So we increase innovation. That's what we learn at school. But in fact, what happens in the market right now is in some areas quite the opposite. Software, for example, have shown that there is huge innovation, but despite patents, because there are a lot, but there are a lot of people who don't like intellectual property in that field, and yet there is innovation. So that stimulates the question between economists and legal practitioners. What is the relationship, if there is still one? So these are the typical issues that need to be dealt with in the coming 10-15 years to see what role access to knowledge and intellectual property have.
Thank you so much.